discredit a young girl who's saying that when she was in this
She was
room,
older than the boys.
Supporters of EM and supporters of the hockey players accused of sexually assaulting her clash outside the courthouse.
She was scared.
She was older than the boys.
She was scared, and she did what she needed to do to
was a
get out of
woman
that
too.
situation.
Everybody was an adult.
The drama outside eclipsed by the drama unfolding inside as Justice Maria Correspondent decided what to do about a note sent to her Thursday, signed by a juror. It accused Alex Formenton's lawyers, Daniel Brown and Hillary Dudding, of judging and making fun of jurors. Every day when we enter the courtroom, they observe us, whisper to each other, and turn to each other and laugh as if they are discussing our appearance, the note said. This is unprofessional and unacceptable. The defense teams argued the accusations raise the possibility of a tainted jury and an unfair trial. Correspondent decided to discharge the jury. In a press release, Brown and Dudding called the incident an unfortunate misinterpretation. No defense counsel would risk alienating a juror, the statement said.
Ultimately,
this defense lawyer has no involvement in the trial but isn't surprised by the decision.
and I think once that accusation is made, whether there's foundation or not, it's really going to put things in jeopardy, and that's what's happened.
It's the second time this trial was almost derailed. Early on, Dudding and another juror had an interaction at a food court during a lunch break. There were differing accounts of what happened. The defense called for a mistrial and got one. A second jury was then selected. Now that jury has been sent home, but the trial didn't miss a beat. Former World Junior player Tyler Steenbergen faced cross-examination on the sex acts he said he saw his former teammates engage in with a naked woman.
By mid-morning, it was business as usual, with one exception: the fates of the 5 accused now in the judge's hands alone.
And Katie, the chaotic scenes you showed us from outside the courtroom, they're also having an impact on the trial.
Yeah, there were dozens of people, particularly when EM was testifying, who would show up. And what was happening is that they were heckling the accused and their lawyers, to the point that the lawyers brought this up. They were afraid that this would taint the jury. There were preparations made so that the jury would come in through another entrance. One day, some of those folks actually got in with signs, which again renewed those fears. But now, of course, with no jury, that is no longer a worry.
All right, thanks for this, Katie Nicholson in London. Let's dig deeper into this now with Lydia Riva. She's a veteran criminal defense lawyer who is not involved in this case. Lydia, walk us through the judge's decision. What would she have been worried about if she hadn't discharged the jury?
The judge was concerned that this jury could not be impartial. She had concerns that this jury would have been influenced by their negative perceptions of the defense lawyers, and that this would have negatively impacted their ability to look at the evidence in this case objectively to determine whether or not the defendants are guilty beyond a reasonable doubt.
Okay, so now that the judge is also acting as the jury, how does that change the way the Crown and the defense approach the case? Does it tend to favor one side or the other?
I don't think this will fundamentally change the way either the Crown or the defense approaches their case. A case like this takes a lot of preparation from both sides. The most important witness for the Crown has already testified and been cross-examined, so I don't think it'll fundamentally change much the way they approach their case or their strategies.
So both sides had to agree for this to happen. What does this tell us about how the defense perceives how this case is going?
Yes, both the defense and the Crown must consent to this procedure. I'm sure there were many factors which the defense considered, like the impact on the defendants and the stress and cost of having another redo, but they also would be considering how their case is going, and they would be reflecting on how the evidence of the complainant has gone thus far and how the trial has gone thus far, and whether or not, in fact, the Crown has proven its case for that very high burden of beyond a reasonable doubt.
Now, this doesn't happen very often, so can people still be confident that the system is working?
Absolutely. This is an indication that the system works. Both parties agreed to a practical solution that salvages this trial. The alleged victim testified for 9 days in this case, and this solution allows the case to go forward with an experienced trial judge who has already heard the evidence, knows the law, and is going to be able to make a determination.
Well, certainly an interesting case and an interesting development. Defense lawyer Lydia Riva, thank you.
Thank you.